This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why an insurer who pays a jury verdict has no obligation or duty to appeal that verdict. And he, of course, who represents himself as a fool for a client. In this case, an insurer was punished for fulfilling the terms of the contract of insurance because it was obligated, after paying the claim, to defend a lawsuit from its insured, both in a trial court and on appeal to the Court of Appeals of the state of Illinois, in a case called Isa versus Allstate, a December 16, 2022 decision. Mr. Isa sued his insurer for legal malpractice after it had defended him to a verdict, paid it in full, and refused Mr. Isa's request that it appeal the verdict. Mr. Isa, though not personally liable for any part of the judgment, wanted Allstate to appeal the judgment. Allstate declined to do so. Mr. Isa then filed a pro se complaint, meaning he acted as his own attorney, against Allstate for legal malpractice and breach of duty, alleging that his insurance premiums had increased as a result of the judgment against him. The circuit court granted Allstate's motion to dismiss the complaint, and Mr. Isa appealed. The basic facts of the case were that on October 15, 2017, Mr. Isa was an insured driver under an Allstate auto insurance policy when he rear-ended the vehicle of Alicia Contreras. Mrs. Contreras filed suit against Mr. Isa seeking compensation for property damage and personal injury. Allstate defended Mr. Isa in that action, which Mr. Isa alleged resulted in a jury verdict for Ms. Contreras in the amount of $14,000. Mr. Isa further alleged that Allstate paid an additional $6,000 to Ms. Contreras for damage to her vehicle. Allstate disputed the figures, but both agreed it was well beneath Mr. Isa's per-person policy limit of $100,000. Mr. Isa sued Allstate, claiming both that Allstate's lawyer negligently committed certain errors at trial and that Allstate breached its duty to defend him in the litigation by failing to appeal the jury's verdict. Mr. Isa sought $1,981.88 in compensatory damages, the amount he claimed Allstate had overcharged him for his insurance coverage following the accident. The trial court held Mr. Isa had failed to state a claim on which relief could be granted, and specifically that he had failed to cite any legal authority establishing a duty to appeal the jury's verdict in the Contreras case. The court agreed that Allstate owed Mr. Isa a duty of good faith and fair dealing, but concluded it had fulfilled that duty by defending him in the underlying litigation and fully indemnifying him for the damages awarded to Ms. Contreras. To state a claim in Illinois for legal malpractice, a plaintiff must allege facts establishing that 1. The defendant attorney owed the plaintiff client a duty of due care arising from the attorney-client relationship. 2. The attorney breached that duty. 3. The client suffered an injury in the form of actual damages. And 4. Those damages were proximately caused by the breach. In cases involving litigation, no legal malpractice exists unless the attorney's negligence resulted in the loss of an underlying cause of action. Mr. Isa's sole contention is that the damages awarded to Ms. Contreras were inflated and resulted in a higher premium for his next year's policy. Generally, an insurance policy gives rise to two duties on behalf of the insurer to the insured: the duty to defend and the duty to indemnify for covered losses. Although the duty to defend does not automatically encompass a duty to appeal an adverse judgment, such a duty can arise in the context of the duty of good faith and fair dealing owed by the insurer to its insured, where reasonable grounds are present for bringing an appeal. However, because there was no adverse judgment exceeding the policy limits in this case, there was no breach of duty by Allstate. There was no question that Allstate both fulfilled its duty to Mr. Issa in the Contreras case and indemnified him for the full amount of the judgment the jury rendered in Ms. Contreras' favor. Under these facts, Allstate had no duty to appeal the judgment. Dismissal of plaintiff's complaint with prejudice was affirmed by the Court of Appeal because the plaintiff failed to state a claim for legal malpractice or for breach of duty based on the insurer's election not to appeal a jury verdict falling within policy limits, proving, in my opinion, that no good faith by an insurer goes unpunished. Mr. Issa sued Allstate, who did everything they promised to do by the policy. They defended Issa through a jury trial and paid the verdict of the jury well within the policy limits. Since Allstate could have settled before the trial at its option, paying the verdict was well within its absolute right. If Issa's premium increased, it did so because he negligently rear-ended Ms. Contreras. He, acting as his own lawyer, managed to waste the time of the court and his insurer, costing them both a great deal of money to deal with his suit and appeal that he had no potential to succeed. One would expect that Mr. Issa will never be able to renew his policy with Allstate at any premium, since they'll never recover the cost it took them and that they spent to defeat this spurious lawsuit and appeal. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the link zelma.com/blog. And you can subscribe to the blog post by simply clicking on the subscription button, and you will receive notice of every blog posting, usually 5 a week, sometimes more. And you can also subscribe to the videos on YouTube or on rumble.com. And if you found this video or the blog posting to be interesting or useful to you in your practice, please tell your friends and colleagues so that they can also subscribe. Thank you for your attention, and please give consideration to my locals community and my Substack publications. Thank you again.